aspects of comprehensive estate planning. So when is the best time to start estate planning? The answer is as soon as possible, because unfortunate events such as early demise or medical incapacitations can happen at any age, which means that it's essential for anyone who wants to ensure that their wishes are respected, their loved ones are protected, and their assets are distributed according to their desire. The primary reasons for estate planning is ensuring that your loved ones are financially secure after your death. The next topic, setting your preferences. Numerous financial planners assist clients in outlining their preferences. This involves discussing how clients wish to allocate their finances in the event of unforeseen circumstances. There are 4 various estate planning tools that can be employed to facilitate this process. First is the last will and testament. The last will and testament is a legal document on how a person's assets, property, and belonging will be distributed and managed after their death. For those aiming to safeguard their estate and ensure its rightful transfer to heirs after death, drafting a last will and testament is an option. These legally binding documents can help prevent potential family disputes in the future. To create a will, the individual must be at least 18 years old and has a sound of mind during the process. In the Philippines, there are 2 types of wills are recognized: the holographic and notarial. A holographic will is a document personally written, dated, and signed by the creator, also known as the testator. In contrast, a notarial will must adhere to the requirements outlined in Article 805 and Article 806 of the Civil Code of the Philippines to be considered legal. The Article 805 states that a notarial will must be subscribed by the testator or by someone else in their presence and at their directions. The will must have 3 credible witnesses executed freely and voluntarily by the testator. In Article 806, every will must be acknowledged before a notary public by the title testator and a witness. The notary public shall not be required to retain a copy of the will. Living will, also referred to as an advance directive, serve as a document articulating individuals' healthcare preferences in the event of their incapacitation. These legal instruments provides explicit instructions about the medical treatments or interventions the person wishes to receive or avoid when they are unable to communicate or make decisions independently. It typically addresses scenarios such as life-sustaining measures, resuscitation, organ donation, and specific medical procedures. Creating a living will ensures that healthcare providers and family members understand and adhere to the individual's predetermined choices regarding medical care during critical situations.
Revocable living trust is a legal arrangement kung ahan nimo i-transfer ang imong asset into trust while buhi pa ka. Like, ikaw mismo ang magpili sa tao nga himuon nimo trustee, then maoy mo manage sa imong mga asset para sa imuhang designated beneficiaries. And since the trust is revocable, you can change or cancel it at any time. One major benefit is that your asset can bypass probate. This is the example of revocable living trust. Si John is 65 years old, retire. Naa siya'y balay, several bank accounts o investment. Para sure siya sa iyang assets kay ma-manage og sakto during his lifetime. So iyang gi-transfer sa iyang anak without the delays and cost of probate. So si John, nag-create siya og revocable living trust, iyang gi-transfer tanang titles sa iyang balay, several bank accounts, and investment sa iyang trust. So ang napili ni John is si Mark as his trustee. So, siya ang manage if si John is incapacitated or namatay. Tapos, sa trust document na I-state si John nga tanan assets held in the trust is mapadulong sa iyang anak. That is the example of revocable living trust. Power of attorney is a legal document that grants an individual agent the authority to make decision on behalf of another person, and a powerful document that requires careful consideration and planning. It's essential to consult with an attorney to ensure power of attorney aligns with your wishes and meets specific needs. And there are types of power of attorney. First is a general power of attorney. Allow agent to make broad financial and legal decision. And limited power of attorney grants agent authority over specific financial asset or transactions. And last, medical power of attorney. It is a healthcare decision. In succession planning, different types of POAs ensure that financial, legal, and medical matters are handled efficiently in case of death or incapacitation.
Next is determining beneficiaries. Lastly, it is crucial to clearly identify beneficiaries and stipulate how assets should be distributed among them. Given the potential for changes in assets, valuations between the planning and execution phases, investors can designate a percentage for each beneficiary. If the assets are indivisible, they may be liquidated with mutual agreements or after a specified period. Alternatively, a trust may be established with assets invested in a specific manner and only the resulting earnings provided to beneficiaries. And lastly, minimizing tax implications. The final and crucial steps involves minimizing taxes on wealth transfer. Both gift and estate taxes can substantially reduce the transfer wealth. Engaging the services of a professionals during estate planning is essential to ensure that intended beneficiary receive the maximum amount of money. Overall, estate planning is a vital component of comprehensive financial planning. While contemplating scenarios that trigger the execution of the estate plan may be challenging, prudent investors recognize its significance. Prioritizing this plan ensures preparedness for a range of situations, making it an essential aspect of sound financial management.
Inheritance regulation. Here in the Philippines, inheritance law are governed by the Civil Code, which enforce a system known as forced heirship, which means nga that portion of decreased person state called legitim is legally reserved for compulsory heirs like bana or asawa, anak, or parents. The person making the will cannot freely dispose of his portion, or it is protected by law.
Next is tax consideration. Tax consideration. State taxes in the Philippines have experienced change, particularly with the implementations of the Tern Law, which is lightened the tax load for the similar statement. For tax considerations kay for my own understanding sa tax considerations kay consider lang gid siya for low tax considerations tungod kay change siya every yearly or monthly ang tax. So it depends lang po dayon na sa company or sa small business or big company lang gid for taxes.
Prevent family disputes. When individuals leave the task of dividing their property solely to their family members, it can sometimes lead to disputes and conflicts among heirs. Different opinions, expectations, and interpretations of intentions may arise, creating a tension within the family. To avoid such situation and ensure a fair and orderly distribution of assets, seeking the guidance of an estate planning attorney is recommended. An experienced attorney can assist in creating a comprehensive plan that reflects the individual's wishes, minimizes potential disputes, and promotes an equitable distribution of assets among beneficiaries. This proactive approach helps in preventing family feuds and contribution to a smoother transitions of wealth.
And that's all for Module 14. I hope you have a clear understanding of the key concept that we discussed.